hopefully everyone can hear me okay, but Carl Marsden is kind of Carl's been doing this for a long time. I think 36 years, 37 years, something like that. So he's got tons of experience, and was involved in real estate, and obviously still is. But he's been doing that for years and years, and then in the last couple of years, he's done a little bit more focus in the areas of wills and estate planning. So he's got lots of knowledge in that area as well. And then the way probate and real estate kind of come together. So Carl's going to kind of do quite a bit of the talking, and then I'll jump in as well. But we want to have this kind of sort of open and a free discussion. So feel free to jump in at any time with any questions or comments. And what I'll do is I'll just watch the little comment box as well as we're going, and then I can jump in and answer any questions as well.
Sure. Morning, everybody. Thanks for coming. What we're going to talk about this morning are kind of three key issues that we'll cover. One, I'll talk about powers of attorney a little bit. So if you end up getting listing some property or dealing with anybody who has to sign by way of a power of attorney, I'll give you the ups and downs of that story, how to make sure you're ahead of the game and not at the end of the game, which a lot of people end up doing, which causes some grief. Kevin will talk about probate. So if you're listing some property, there's an estate involved, what that probate process looks like, and the timing of it is key. And how soon should you take a listing, and how soon do you think anybody can complete on the deals? That seems to be a mystery today. Everybody assumes as soon as the guy dies, the property can be sold and dealt with in the next month. Not so. So Kevin will run through that. And then at the end, I'll just jump back in and kind of go through. You'll hear in the air a lot. Well, how do we avoid probate? Older people don't want to pay taxes. How can we avoid probate and probate taxes? And I'll give you the pros and cons. There's one pro and about 10 cons to that. And so if anybody's encouraging people to add their kids onto title or other such things, I'll probably try to discourage you from doing that for a bunch of reasons. So I'll start with powers of attorney. So sometimes you're gonna end up with clients who have either some incapacity, they don't have the capacity to execute listing or contracts, but for whatever reason the property has to be sold, or is in the process of a sale, they become incapacitated, or if they're at distance, if they've gone on, and I've had this happen, where they've gone on a cruise to the Indian Ocean and suddenly forgot they've got a real estate deal. People always tend to go away when they got real estate deals closing within the next month. So can they assign their attorney under a power of attorney to sign documents? So powers of attorney are used to handle legal and financial affairs for those who typically are incapacitated, but they can also be used if you do have capacity. So most powers of attorney drafted today by lawyers, at least, and notaries, are what we call enduring powers of attorney. So they're effective if you have capacity or don't have capacity. And then typically what happens if they're lawyer drafted, there's some conditions put on the use of them. So we typically would hold them in trust until either the person, we can confirm the person's incapacitated, then hand it out to the spouse if there's a spouse, or kids in a certain order. Or if we get instructions from the client, we can release it, do a notarized copy for a specific purpose, like closing a real estate deal. The key is, from your perspective, is making sure there is a power of attorney in existence, and it's typically in a BC form. So a lot of people who are coming from the prairies are dragging their estate planning documents with them, or from other jurisdictions, and it may not, their powers of attorney created in Saskatchewan or Montana or wherever may not be effective here in our land title office. So it's critical that you get a copy of the power of attorney, understand where the original is, because the original has to go up to the land title office and be filed and accepted by the land title office as an effective document before any deal can be closed. So the earlier you can get in the game, the better. The other thing I caution you about is does the person who has the original power of attorney really have the authority to use it. And you'll remember there's been this terrible case in Lumbee where the mom had her original power of attorney at home. Her son got a hold of it, made a copy of it, and sold her house on her with a copy. And the lawsuit's still erupting. The son had the courtesy to die of a heart attack before the deal closed. There's a massive lawsuit erupted with, did he have the authority to actually use it, let alone use a copy of it? So all of those questions. And I suggest that as soon as you understand there's a power of attorney involved, that you get the lawyers working the deal to have a look at it, get the original, and make sure that those people have the proper authority to use it. And the legislation and the law is very clear. You can only use a power of attorney for the benefit of the person granting it to you. In other words, you can't, and this is typical, you got a senior who's incapacitated. The kid's going to sign some real estate deal and then divvy up the funds with him and his siblings. That's completely illegal. So again, if you get wind of that, and we as lawyers have to ensure the funds go into the account of the parent and for their use and benefit, not for the kid's use and benefit. So all those issues, it should be dealt with early in the game, and you should get somebody who knows about them early in the game involved. Don't wait to the end. And it does take a week or two to get that power of attorney up into the land title system to be able to use to sign conveyance documents or whatever. So a lot of prep work has to go on in advance. Okay, any questions on that? Clear as mud? No.
Maybe I'll just add a little something on powers of attorney. So before real estate can be transferred, you actually need to register that power of attorney in the land title office, and you get what's called a deed file number with an actual number. So if you've got somebody who's selling by way of power of attorney, I think the best thing to do is to register that as soon as possible, so you know that there aren't going to be any hiccups when it comes time to register, because there could be some sort of an issue with the power of attorney. Maybe it's not signed by everybody. Or there could be some technical issue that causes it not to be registerable for some reason. So I think the sooner you can do that, the better. Also, when you're dealing, Carl talked about powers of attorney from other jurisdictions. You can use them, but it definitely becomes tricky. So you're much better off if you've got a BC generated power of attorney document, because we've dealt with a couple where people are selling property based on Alberta POAs, and there's some extra steps that have to be done, affidavits and that sort of thing, and original documents, not just copies, have to be submitted to the land title office. So it definitely takes a lot longer.
How do you actually do that, Kevin? Like if there's only one original document, how is that being kept safe? And how does land titles see it? Like, presumably you're not just mailing this thing if it's that important.
Yeah. Go ahead, Kevin.
Go ahead, Carl. Yeah, you can answer that one.
Yeah, we need the original document to certify it's an original. When we upload basically a copy of it and get the original back to the kid, whoever's got it. So, but we need the original to do the initial registration. Okay.
All right. So you're able to confirm that it's the original. You don't have to physically send that to land titles.
Well, yeah, basically a copy of it's uploaded. We've confirmed it's an original, and then we've uploaded a copy of it. So we've certified it's a copy of the original. But to do that, we need the original, and then we get it back to whoever's holding it. But
I apologize that I came in a couple of minutes late. I've got a situation where I'm representing a buyer buying from a seller who has deceased, and the listing is in probate.
right.
So right now I think I'm powerless to do anything, but any advice when you're representing the buy side in that situation?
Well, Kevin's going to talk about the probate process once we're finished with powers of attorney. So you're just slightly ahead of us here. Okay.
Oh, I'm definitely behind.
Any other questions on powers of attorney?
Would you recommend to a couple when they buy a property, for instance, they don't have a power of attorney right there, then when they're signing the documents, they also have a power of attorney drawn up, because it is important to get it done as soon as you can?
Well, yeah, I think any adult should have estate planning set of documents, always will, a power of attorney, and a rep agreement, no matter what. Who knows if you're going to have a massive stroke or be in a brain injury, a car accident. Suddenly, if you don't have a power of attorney and those events happen, the route you have to go is the surviving spouse or the spouse who's left or whoever. That's the only course of action after that to act for them is to get a court order under the Patients Property Act to be appointed a committee, which is like a court order appointed power of attorney and rep for healthcare. That process requires 2 doctors to assess the person they're incapacitated. And then those affidavits of those 2 doctors has to go, an application has to be made to a judge. That takes months. And the last I heard, somewhere 4 to 5 months and a $25,000 or $30,000 bill to do it. So, it's like getting insurance every year, either in your life or your car or your house. It should just be automatic. And it wouldn't be a bad idea as a realtor. Do you have these documents in place in case something happens? And if they don't, recommend they go get them in case something happens in the interim. It's not a bad idea.
The one other thing that we do when we've got buyers is we ask them if they've got estate planning documents like power of attorney and that sort of thing. And we just always want to make sure that the name on title is exactly the same as it is on a power of attorney. So we do ask them that question, and it's definitely a good idea for, as Carl said, for everyone to have one. So yeah, I'll jump in and talk a little bit about probate. I think everyone knows the difference between joint tenancy and tenants in common. Joint tenancy, where 2 or more people own property as joint tenants, and if it's in joint tenancy, it'll be very clear on title that it's held in joint tenancy. And if it's joint tenancy, somebody passes away, really easy to transfer the title to the surviving joint tenant. All we need is an original death certificate in our possession. And then what we can do is we can electronically transfer title to the surviving 2 joint tenants or single joint tenant. But it's always really important for you to look at title, because a lot of times people will think the property's in joint tenancy and list the property, and then when we take a closer look, we realize that it's not in joint tenancy, and we've had that situation a couple times this year. And you can a lot of times just have a 1% interest holder who passes away, and that interest is held under tenants in common, and it results in somebody having to probate the estate just before you can transfer title. So really important, anytime you're listing, just make sure you have a good understanding of what title looks like, and make sure that if somebody's not well, that you see if it's in joint tenancy or how title's held. If you have any questions, you can always reach out to Carl or myself or Sheridan. So probate, a lot of people ask, what is probate? And kind of a simple way that I look at it, it's just getting permission from the court registry to actually transfer title. So it's a formal process that you go through. You determine the assets of the estate, provide notice to anyone who's entitled to notice, which would be people named in the will, or spouse or kids are automatically entitled to notice. So you've got to provide notice to everyone. Again, determine the assets of the estate, present that to the court registry. They review the application, and if they're satisfied with everything, they'll issue a grant of probate. And that Carl knows much better than I do, but it's a number of months, and it looks like once the application is done, it's taken the local court registry 8 to 10 weeks to actually issue probate. Before you can even make the application, as I said, you've got to provide notice, and you have to wait until that notice period is up before you can actually make the application. So it's probably a 3 to 4 month process, maybe longer to get probate. So you know, if you've got an executor who's come to you and said, look, you know, somebody's just died, I'm going to list and sell their house, just know that it's going to take quite a while before you can actually transfer that house into the name of the executor so that you can sell it. So we do get asked the question all the time, you know, can we list the property through the executor when probate is not granted? And on your BCFSA website, it's very clear that you know, they don't recommend listing property until you are satisfied that probate has been granted, or you've got you know, maybe a lawyer giving you some advice that this is the executor of the estate and they do have the authority to list the property. So yeah, I would just take a look at you know, what they've got on the BCFSA website, because it's important that you know that, you know, whoever you're dealing with actually does have the authority to you know, list the property, enter into a contract, because there are things that can come up. You know, there could be another will that comes up with a different executor. So you don't want to be caught in that situation where you're competing with somebody else over the right to sell the property.
Just jump in for a sec. With the blended family story today, probating an estate used to be fairly straightforward. Who's the executor? Let's probate it. But these competing claims now, with 1 or 2 spouses, potentially kids, fighting with the new girlfriend, etc., and whether she was a spouse or not. And what we're starting to end up seeing is, once the probate process is applied by whoever had the story, others are fighting, and they'll put a caveat again at the courthouse and freeze the probate application. So again, you should look at kind of the family dynamics. If it's a normal family, there's not many of those left anymore. But if it isn't, there's a potential for conflict and to get the thing frozen. So just heads up. So we typically wait until the judge is ready to issue probate, and he lets us know what the probate taxes are, pay those, and then we usually get the probate order within 2 to 4 weeks of that. So that's kind of a time where you're pretty much assured that probate is going to be granted, and then maybe you can start listing at that point, but not so much before that.
Yeah, it's always a difficult time because everyone's really, you know, generally pretty eager to do something with the property. It's not easy to leave a property vacant because of insurance and everything else. So typically the executor, or whoever's claiming to be the executor, does want to jump in and list the property, and they're probably pushing you to help them out and list the property. And it's always nice getting listings, but you do need to be really careful that you know, this person does have the authority to actually list the property. So I would, you know, as Carl suggests, you know, make sure that you have the application sort of done, and you know, hopefully no one has challenged the appointment of that person as the executor, or there's not another will that pops up. So the next, unless there are any questions on probate, maybe Carl, do you want to talk a little bit about you know, some of the language that should be in the contract when it's subject to probate?
Yeah, so we've got a handout that it's gonna be sent to you by Anna, and there was a recommended language we've attached there that the Real Estate Association has provided. There's 3 paragraphs, and it says subject. I'll just read it because it's unfortunately not in front of you right now. First paragraph says a copy of subject to the seller obtaining and providing the following by a certain date: a copy of the grant of probate or letters of administration allowing the property to be sold, called the estate documents. That paragraph's fine. Paragraph 2, confirmation that a transmission of the title to the property to the administrator or executor appointed in the estate documents has reached final registration in the land title office. And that's fine. So what happens once the judge grants the letters probate, we get a certified copy of that and register that at the land title office. It does take a little bit of time, usually a few days, to get it actually in the name of the executor, so they're in a position to execute the conveyance documents. It's paragraph 3 in that standard language that we suggest you take out, you don't have. It says, assurance of the seller satisfactory to the buyer that everyone entitled to claims under the Wills, Estates, and Succession Act has waived or released their claims in relation to the property. That is way too broad, and there's only one person who's entitled to make a claim against the property, and that's a spouse, if she is a spouse or he is a spouse, and that's pretty fluid what a spouse is these days. And it's been living in the property as a residence, but it's not on title. That's the only person who can actually register a Spouse Protection Act claim and freeze the ability to convey, to deal with the property. So that the way that language is in paragraph 3 in the Real Estate Association precedent is way too broad. And so we suggest you take it out, and then lawyers deal with ensuring there is no spouse on the story, getting stat decks, etc. And even the land title office will want a stat deck to make sure there's nobody that's going to be filing a claim. So you don't have to worry about that issue in paragraph 3. Anybody else who has a claim in the probate process and under wills variation sections, spouse and child can challenge the will if they don't think they have their fair share. All they do is have a right to a share in the ultimate assets that have been liquidated, not to any specific property. So that's dealt with in another process and wouldn't hold up the sale of the property. Okay.
You know, a lot of times we will, you know, if you're acting for a buyer, the buyer wants kind of a certain date to close and to move into the property, and if probate is delayed, there can be an issue because, you know, maybe that buyer has sold their house and will be homeless. So, you know, a lot of times we'll see in contracts that, you know, the sale is subject to probate. And then there could be additional language in there that says that, you know, but if probate is not issued by the closing date, that the buyer, the seller will allow the buyer to occupy the property pursuant to a tenancy at will. And, you know, a tenancy at will is really just an agreement between the executor of the estate, the seller, and the buyer, where the buyer agrees to move in, cover certain costs relating to the property, take out their insurance, and you know, ultimately close when probate is granted. But it's a good vehicle to sort of stick to a certain date and allow the buyer to move in. A lot of times the language in the tenancy at will, though, can be pretty restrictive, and it might say that, yeah, sure, the buyer can move in, but the buyer's got to agree not to make any changes to the property, do any work to the property, that sort of thing. So we recommend that if there is that language in the contract saying that you know, if probate's not issued by a certain date, that the seller will grant permission to the buyer under a tenancy at will, that the buyer and the seller actually agree on the language of the tenancy at will ahead of time. And you know, we've done that in a recent real estate transaction. The seller's lawyer was great. They put together a draft tenancy at will. We got it to our client, who was happy with it. And sure enough, we weren't able to transfer title on the closing date in the contract because probate wasn't issued. But we had the tenancy at will in place, and everybody knew what the terms were. And our buyer moved in and was able to close 3 weeks later. So it worked out really well.
That tenancy at will is a great idea. Had clients, we tried to do that a few years ago, but for a strata, the strata would not allow any rentals in their bylaws, so we couldn't do that.
Yeah, you're absolutely right. I mean, that's a good point. You know, typically stratas are a little bit more restrictive, so that's something you'd have to look at for sure. Yeah. Kind of the next sort of topic area we were going to talk about is avoiding probate. So Carl, do you want to jump in and
Sure. Yeah. So you'll hear a lot of, we get approached by a lot of clients, particularly elderly clients. Nobody wants to go through the court process, and can we avoid probate and avoid paying probate taxes? So it just as an example, if the last of the surviving parents passes and they have to probate their estate and they've got $1 million house, as Kevin's pointed out, it takes some time to probate that. Plus there's obviously the legal fees to that can range anywhere from 5 to 10 grand. And the probate tax on $1 million house, if there's no mortgage, it was 1.4%. It's not huge, but it's still 14 grand. So that process, and not only the time it takes to probate, but the cost is around a $20,000 exercise. So a lot of people jump in and will say, well, how do we avoid it? So there's two key ways to avoid it, and they all have their traps and problems. And one is to add the kids to the title. And this, it's the only good news in it is you might avoid the probate taxes, but it has a lot of problems associated with it. And if you're going to go that route, the only time I'll do it is if the parent is definitely terminal and has less than a month to go, then maybe we'll do it. But the problems that erupt are one, who are you adding to title? So if there's a bunch of kids, do we add all the kids, or do we just add one kid? And if it's just one kid, you add them to the title as a joint tenant, so it's a right of survivorship, you can avoid the whole probate process. But on the face of it, it appears he has a right of survivorship with the jointure. So you got to be careful that there's some sort of document that says that that's the case, it's a true gift to him, a right of survivorship. Or failing that, he's really holding a trust for the estate to be split with the other kids. So you need some further documentation, make it really clear what that is or isn't. So aside from that, the other headache is if it's the parent's principal residence and you add kids on title. And a great example was a few years ago, gal thought she was terminal, had a home on Okanagan Lake around the year 2000. She thought she was terminal, added the 5 kids onto title, and she survived. Didn't take the kids off the title. Passes away just recently. Anyway, she lost the principal residence exemption on 5/6 of the properties. You can imagine how much it's gone up in value since 2000. The tax bill, the capital gains tax bill, because it wasn't only 1/6 was the principal residence, $600,000. So trust me, the 1.4% is a lot less than $600,000. That was the tax bill. So the principal residence tax issue is an issue, and how you deal with that. And then are there issues with the kids that you're putting on title? So any interest that you put on title could be hit with a judgment if that kid has creditor problems or is bankrupt. That interest could be subject to bankruptcy or creditor issues and spousal issues. If they have a partner who's claiming an interest and they break up, that interest could be subject to a matrimonial dispute. And even if you can prove there's a trust agreement in place, it will be dragged into a dispute. And the last issue is control. And I've had this a couple times where parents add the kid onto title, avoid probate, then they want to downsize, want to use the home to get into something smaller or get into a retirement bill, and the kid says, no, I want the property, I'm not going to sign anything, and that's it. You can't go to court and get a court order to punt the kid off. So they're stuck. And we had one deal where there was a sale, kid refused to sign it, money had to be paid into court, parents were trying to move into a retirement place and they couldn't, they didn't have the cash to do it, that was supposed to come from the house. Kid fought it and ended up in court for a year or two. So you have to be really careful with that idea of adding kids to title to save the whole probate story. The other way around the probate is if you're 65, you can roll all of your property into a trust called an alter ego trust or a joint spousal trust. This gets a little more sophisticated and complicated. And then the trust owns the property. You can roll your property in tax-free. It doesn't trigger any tax, but you have to be 65. And then the trust takes over running and managing the property. The issues that have popped up recently, it's expensive to set up a trust. All the property has to be rolled in. Typically, you have to register the trustee of the trust on title to the property. That could trigger property transfer tax. So you think you're saving the 1.4%, but the property transfer tax might actually be as much or more. And then managing the trust, you have to file, there's a couple of different filings in Canada. Any income earned in the trust could be at the high rate of 53%. So you really got to watch. If you do that, you really need a tax person involved to understand what every asset's doing, what the tax consequences are. And that's used, sometimes used to avoid probate. It's basically used in a lot of cases in the blended family story where there might be a potential claim by one of the kids who's gone AWOL, who's got an addiction issue, or there's been an estrangement or whatever. Because kids on a death, kids can't attack the trust. They can attack a will under will's variation provisions because they're a spouse or child, but not in the trust. So it's used for that quite a bit. So there's avoiding probate. I don't think it's worth it personally, unless they're on their deathbed, let them pay the 1.4% and go through probate. All those other issues, those other 7 or 8 issues I discussed, can raise their ugly heads and cause a lot of grief, particularly from a tax point of view. Okay. So if anybody's thinking of doing it, tell them to get some decent advice from good tax people and some lawyers. Any questions on that? Or?
If they want to, if someone did look at doing this and they're not just about to buy something that's all an existing house, if they want to add their kids to title, does that attract property transfer tax or not?
Again, it'll depend if the house is the principal residence of the person transferring it, or the kids, if they've been residing in it for at least 6 months and they're related parties, i.e. their children or spouses of children, there's a property transfer tax exemption for that. But if it isn't, if it's investment property, you're adding it will, 1, trigger capital gain, and 2, trigger property transfer tax. So you got to watch the tax issues. Good. Anything else? No. Any other general questions, roughly, on estates or wills or powers of attorney or anything like that? Or if you have any other questions that pop up, feel free to fire an email to Kevin or I, or phone us, or whatever. Happy to discuss any problematic file you have and help you through it.
I actually do have a question. Sorry, my face is a little dark in the sun here. Can you hear me?
Yep. April.
So my client, his mom passed away in January. Everything was simple. It was just a money transfer. How long is it usually until they receive the funds? Because when he asked their lawyer, they said the funds were received by the bank and just waiting to be sent over. Do you know what an approximate time nowadays is for that?
Well, it depends. Probate, you only have to probate an estate for certain assets. So anything registered like land, vehicles, etc., you have to probate. In terms of bank accounts and investments, typically the financial institution will have a limit above which they'll want to see probate. So in your case, it depends on how much money was in the account, but usually if it's over 10 or 20 or 30 grand, they'll want probate. So again, as Kevin described, you'd have to go at the whole probate process of getting the documents together, making the application. And as Kevin pointed out, it's about 10 weeks once you file it with the judge. So it was almost 3 months. So you're in a 4-month process or so from the actual filing of the probate application. So it depends on where the lawyers are in the process. And then once you get the probate order, you can go cash out the accounts to get the cash, or if there's land involved, try and put the probate order on the title to allow the executor to deal with the property. So it depends where. Okay.
Right.
Just generally, the whole probate process takes a long time. So it takes a number of months to get probate, and then before you distribute the assets, you want to make sure that there's no money. The executor always wants to make sure that there's no money owing to Revenue Canada or anyone else. And so what we typically require from CRA is a clearance certificate, and that just confirms that that there's no money owing by the deceased. And then the executor feels pretty comfortable that they can go ahead and distribute the assets, and it takes a long time to get that, because you've got to file you know, sort of the last year, the last tax return, you've got to file an estate tax return. You've got to wait for a notice of assessment from CRA, and then you can actually make the application for a clearance certificate. So, you know, a lot of times, you know, it can take a year and a half, 2 years before you're paid out on an estate if you're a beneficiary.
Gotcha.
The other thing that holds things up is once the probate order is granted, anybody who has a claim under will's variation, a spouse or child, has the right to challenge the will within 180 days of the grant of probate. So if they don't think they've got their fair share. So I always plan my estates, give the kids their equal shares, because if you don't, if you make it uneven, you're gonna tempt the fates on a will's variation action and hold the thing up. And the kid's gonna get his fair share overall, but you're going to spend 2 or 3 years in a courtroom, destroy the estate and legal fees. So typically what happens is once you get probate order, you can cash things out and understand what your tax position is. The lawyer, we would prepare an accounting with the help of the accountants as to what the estate looked like when they passed, what is being liquidated for, what things are owing taxes and bills, etc. And here's the net amount available to all of the beneficiaries, and send out a copy of that accounting to all the beneficiaries and ask for their consent, and then a release. And that cuts off their ability to make any claim under will's variation if they all sign it. If they don't all sign it, you got to wait out. You actually have to wait out 210 days, because anybody who wants to make a claim, it's given 180 days, but there's a 30-day process to actually deliver a copy of the legal process to you. So it's 210 days past the probate. So that's how we shorten it, but all of that stuff has to happen in between. So it's quite a process, actually. But.
All right. Well, I appreciate that. Thank you.
Would you recommend for parents to sort of drip feed their estate to the kids over a period of years if they're just getting elderly, or is that a bad option as well? Like, do the kids get taxed on that, or?
Well, gifts from parents and gifts through the estate are all tax-free in Canada. No issue there. The issue is today it's not unusual. You know, what are the needs of the parents to get to the end of the game? We're all living longer, and I really caution parents. You know, I went a little while ago. You know, they sold a house for a couple $1 million. So let's give the kids $1 million. Well, he's got some health issues, and this is not uncommon. And you know, he's probably got 50 or 20 years to live, and suddenly it comes down with an issue, and it's a $5 or $10 grand bill a month because the system is going to take care of you. So you got to really be careful that you've got enough to get to the end of the game, and not rush to gift it all out the door. You know, if you got millions and millions, sure, but aside from that, you got to make sure you've got, you know, it's not. I saw a couple a little while ago. They had $2 million they were going to gift it out, and then both had issues. It was 10 grand a month for each to get them to the end of their lives for the healthcare they needed. So that burned up pretty quick. So I'm not keen to tell parents to gift stuff out to kids. They got the rest of their lives if you've done it properly and raised them properly, give them the tools to get to the end of their, you know, they're not, you know, basically welfare cases, to get to the end of their lives and ensure that you get to the end of your life. But
Great. Yeah, you know, I hopefully you guys found some value in this, and then as Carl said, you can you know, shoot either of us an email. And Carl's got tons of knowledge on real estate and then wills and estates, so feel free to reach out to him.
I've got one question if you have time.
sure.
So once probate is granted and you've got a title in the executor's name,
Right.
and you've got a property listed, accepted offer, and you're pretty much good to go. Subjects come off, you are 100% good to complete the transaction, and and the title can change to the buyer's names.
Right. That's right. Yep.
Okay.
Yeah. As soon as that probate order gets registered on the title, it gives the power to the executor to complete the deal, to sign off, and the land title office will accept a transfer signed by an executor, the probate order pre-filed at the land title office. Without it, they can't move. It won't go through land title office.
May I ask a question about other estate property, such as vehicles? Can they be sold and the proceeds be put into trust subject to probate, or do they have to wait till probate to be sold? Or, yeah.
We're able usually, dealing with ICBC and the insurer, to give an undertaking that we should provide a letter to the ICBC. We're acting for the executor or administrator of the state. Here's a copy of the will if there is one. Here's a copy of the death certificate. And they usually will put it in the executor's name, or allow them to transfer on our undertaking to file a grant of probate with them. And or they will waive getting probate if the entire estate that has to be probated is less than $25,000. And again, they still want some sort of a acknowledgement that there's what we call a bond of indemnity, that if somebody makes a challenge to them doing this for you, that they'll hold them harmless. But we usually can work to get the vehicles out in advance. But one mistake that executors make, and this is for your own education as well, is they're tempted, for whatever reason, there's a number of vehicles, to let family members start using the vehicles. A person's passed away and I'm going to go get probate. They have control of the vehicles. The key is to just store them and leave them alone, to make sure insurance is in place. I've got a few cases over the years where they let somebody, a kid and a nephew, whatever, a grandkid, jump in the car and take off, and then there's a terrible accident. The kid's been doing drugs or drinking. No insurance. There's a multi-million-dollar claim against the estate. So the estate's wiped out by the lawsuit, and the executor's then sued for negligence. So just a little side issue. So be careful on the vehicle story, but until you've conveyed title to it to somebody else, obviously. But
Great. All right. Well, thanks so much for your time. Hopefully you guys found some value in this.
Yeah, thanks so much, guys, for coming. Really
Yeah.
appreciate it. Okay, have a great day.
Bye.
care.
Thanks, guys.